Good afternoon. My name is Sherry Sutphin. I'm the magistrate for Seminole County. We're going to go ahead and get started. The way that the process works is when you come up, you'll have a seat at the table. You will be sworn in. The county will present its case first. After the county has an opportunity to present and close its case, you will have an opportunity to present your case. You will have an opportunity to cross-examine witnesses of the county if you would like, and they also can cross-examine you or your witnesses. This is a pretty informal process, so I may interject and ask questions at different times as well. But I will make a decision here today. If you're here for a first-time violation and you are found to be in violation, if you do not comply within the time set, you stand a chance to have a fine of up to $250 a day imposed. If you're here for a repeat violation, you stand to have a penalty of up to $500 a day imposed. And then we also will hear compliance hearings today for cases that have been before me on a prior occasion. So if you're following along with the agenda, we usually do not go in order. We try to get people out as quickly as we can. And we have a pretty large crowd today for 2404 CESM, Tuscaloosa Park. So I'm going to go ahead and call that case first.
Thank you. Hello.
Hi.
I represent Tuscaloosa Park SCLTD. I'm one of the managing members of the partnership. And I'm here to say that...
Okay, wait 1 second.
Okay.
So do you have other individuals that are going to testify for you?
Not unless my architect needs to say anything on our behalf.
So anyone who may provide testimony, if you'll raise your right hand, and then county staff members that are going to provide testimony, if you will raise your right hand, do you solemnly swear or affirm the testimony that you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay. So the county, if you'll wait 1 second, the county will go ahead and go first on this case, and then we'll hear from you.
That was Amy's case first.
Sorry. I did that. I called him out of order.
Yes, ma'am. Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to case number 2404 CESM Tuscaloosa Park SCD LTD. This is at 1427 Tuscaloosa Road, Unit 245, Winter Springs, Seminole County, violation charge, Seminole County, Chapter 40, Appendix A, Section 105.1. The description of the violations, interior alterations, including but not limited to the installation of new walls, electrical, plumbing, without the required permits. This is a screenshot showing you that the Tuscaloosa Park SC LTD for case number 2404. Initial inspection was done on 6/6 of 23. Notice to the respondent went out on 6/7/23, given a compliance date of 7/12 of 23. We had several different follow-up visits in person, also via computer. You can see results of the inspection for the violation remains on the property. This is a picture of the property appraiser's website showing that the property appraiser's website showing Tuscaloosa Park SC LTD is the record owner of the property. This is a certified copy of received return receipt mail for notice of hearing. This is a screenshot that was done on 1/12 of 23 for the violations, and they still remain on the property. This is a picture of a stop work order that was posted by the fire marshal in the very beginning that was done on 6/6 of 23. These are pictures of unpermitted interior alterations that were done, and again of new walls. Again, we've also got firewalls here, electrical and plumbing running through them. And then, again, a picture of the fire marshal's posted stop work order. This is a copy of the permit screen, shows that permit 23-13829 is in PC, which is plan check status as of 11/13 of '23, pending corrections from various departments. Permit number 23-8858 is for a sign that is done. Permit 22-16121 is for a fire alarm that is done, in done status. This is a copy of the application date for plan tracking information that shows that the copy of the permit application dated 9/1 of '23. What is this here? An E-plan here, we're seeing that there's applicant accepted task, no further action has been taken. And the building electrical, mechanical, plumbing permit review date, along with the results of 11/13 of '23. Contact date with applicant as to the corrections needed to review is 11/13 of '23. Contact date with the applicant is ready for issuance. Okay, this shows that the copy of the Chapter 40 in which they are in violation of. This is the recommendation based on the testimony and the evidence presented in the case number 2404 CESM. It is determined that the respondents are the record owners of the property located at 1427, which is 1425 Tuscaloosa Road, unit number 245, Winter Springs, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondents to correct the violation on or before April the 10th of 2024. In order to correct the violation, the respondent shall obtain the required permits for the cited violation. If the respondents do not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Okay, would you like to submit your electronic case file into the record?
Yes, ma'am, I do.
Do you have any objection to the electronic case file that you received, the packet of information being submitted into the record?
No.
Okay. Okay. It's your opportunity now to go.
Okay. As an owner,
If you'll state your name, please. for
my
the
name
record,
is
sir.
Stephen Levin.
Okay.
As an owner of the property, I was just recently made aware of the gravity of the situation. My staff had not conveyed it to me. We have taken steps to help the county and ourselves. We have presented the tenant who has caused this issue by failing to get the permits with a 3-day notice, and we have filed an eviction action for both monetary damages and violation of our lease. I'm here to protect the interest of the property. If our tenant is unable to do what they're required by the law and by Seminole County, then we do not wish to have them in our shopping center. I do have my architect here to say that in the event that the tenant cannot do what they're supposed to do, and we have to do the complete eviction, that he will go in, he will review the situation, he will submit the plans necessary to the county, and we will immediately address any and all violations.
Okay, so the violation is for not having a permit.
Correct.
So the county has asked that you just get those permits by April 10th. Is that sufficient time for you all to do that? And the county doesn't have any concern about what goes on with your internal tenant. Whatever you need to do with your tenant, that's fine. But what they're asking is for you to get the necessary permits by April 10th. If you are unable to do that, then can you give me an amount of time that works for you?
Well, if the tenant and their architect or engineer cannot respond in a timely manner to the county and satisfy the county's needs for the required building permits, we're still going to be pressing forward legally. And depending on, our lawyer and the court system here, we'll see what the eviction does. But I urged the tenant to do what is required by the county.
Well, I'm letting you know, though, that as the property owner, you're the one responsible. It's not the tenant's responsibility. So the county is asking you, not the tenant, whether you are capable of getting the necessary permits for the building you own by April 10th. And it has nothing to do with an eviction proceeding. And the eviction proceeding could still go simultaneously with this, but at this point, if this were me, because of how long this has been going on, I would step in and I would tell them, you're not doing this, I'm doing it, and you're paying for it, but I'm doing it. So I need you to let me know how long that you think it will take you all to get the permits.
Jeremy Van Ice, Level Up Architecture. As the landlord's architect, I've had the privilege of being able to work on the shell building prior to him leasing any spaces, which were permitted and previously approved by Seminole County. As I understand it currently, there is an architect of record that is performing work on behalf of the tenant that there is currently a permit in place for. At this time, I cannot step in as I am not the architect of record. However, if the tenant is evicted, Stephen would then bring me in as the original architect to basically remove the current permit and design the space properly to be under a new permit, would be the intended action, so that the building could be in compliance with Seminole County.
So is there a permit?
There's not a permit that's been issued. There's one that's been applied for. It's been in
That's what I
PC.
meant.
It's been in plan check status since 11/9 of '23. It went back to the contractor, which we've not heard back.
So at this point, without regard to an eviction, without regard to who is the architect of record, I'm asking you as the owner, how long will it take you to get the permit? Will you be able to comply by April 10th, 2024?
I would say May 15th?
I would say May would be more realistic if
Okay,
we were
so-
to proceed through your required evictions.
If we go to May, it would be May 8th, because we always do the day before a hearing, and our next hearing would be the 9th. So does the county have any objection to providing him till May 8th?
I don't. What I would like for him to do is take my business card to contact me, so we're at least in communication with one another, because this has been a property that has not really had a lot of communication unless I've been called out by the fire marshal to shut it down because they're operating without their permits.
Well, I apologize for that. The staff that I had on site there was not communicating or sharing the violations with me, and have since been terminated. So we're going to do our best to be in contact and get this in order for the county and for the shopping center.
Okay, great. I would appreciate that. Okay, I'm going to go ahead and I'm going to find that the property owner was properly noticed to be here, that the property owner is present and represented today. I'm going to find that the county has provided competent, substantial evidence to find that the property owner is in violation of Chapter 40, Appendix A, Section 105.1. I'm going to provide until May 8th, 2024 at 8 a.m. to come into compliance, or a fine in the amount of $50 a day will be imposed for each and every day that the violation remains. And I urge you to make sure that you do keep in contact with Ms. Hathaway. I assure you that if you're remaining in contact with her, that's going to go further here. If something happens along the way and you are unable to make this date, then I want to hear from her that you have been consistently working with her.
Okay.
And then make sure once everything is in the system, it's your obligation to contact her to make sure that she is aware that the permit has been issued.
Okay,
Okay?
thank you. I understand that.
Thank you.
Thank you.
Thank you.
Yeah, let me-
So just go in order from there.
Yeah, I'll go.
Okay. Case number 2319, CESM, Eugene and Donna Smith.
Who's that? Hmm? Oh, Sutter Mill? Sutter Mill.
Are you Mr. and Mrs. Smith, Eugene and Donna? Okay, if you'll both raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
We do.
Thank you. Okay, I'll remind the county you're under oath.
Okay, for the record, name is Vicki Hathaway, Building Inspector for Seminole County Building Division. This is in regards to CESM 2319, Eugene and Donna J. Smith. In regards to 3759 Sutter's Mill Circle, Castleberry in Seminole County, Florida, violation charge, Seminole County Chapter 40, Appendix A, Section 105.1. Description of the violation: installation of a generator, transfer switch with associated wiring, gas line, and new sub-panel under photovoltaic equipment without the required permits. This is a picture, a screenshot of the case summary. Initial inspection was done on 8/31/22. Notice to the respondent went out on 9/1 of '22, given compliance dates of 9/15/22 and 10/4/24 of '22. Follow-up visits, inspections were done through the 22 through 23. Follow-up inspections via computer up to 2/8 of '24. The results, the violation remains on the property. This is a screenshot of the property appraiser's website showing Eugene and Donna Smith are the property owners of the property. Copy of the certified green card received on 1/17/24. And a picture of the violation that was done on 2/7 of '24. Violations were taken on 8/31 of '22. Panel that was taken on 8/31 of '22. This was a door knocker that was left on 9/21 of '22. Violations again taken on 11/15 of '22. Generator that was taken on 11/15 of '22. And again on 11/15 of '22. The violation taken on 2/8 of '23. This shows the permit screen where no permits have issued to correct the violations. This is a copy of the Seminole County Chapter 40 Appendix A regarding the permitting process. And the recommendation is based on the testimony and the evidence presented in the case number 2319 CESM. It's determined that the respondents are Eugene and Donna J. Smith, the record owners of the property located at 3759 Sutter's Mill Circle, Castleberry in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. This concludes my further recommendation to order the respondents to correct the violations on or before April 10th of 2024. In order to correct that violation, the respondent shall obtain the required permits for the cited violation. If the respondents do not comply, an order of a fine of $50 a day will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact the inspector to verify compliance. This concludes my presentation.
Would you like to submit your electronic case file into the record?
Yes, ma'am.
Okay. Do you have any objection to the electronic case file, the documentation that's been provided to you being submitted into the record?
No.
Okay.
We had gotten a contractor back in '22, and he got halfway through the permitting purpose and then decided that
Well,
stopped
he
it.
just did, we thought he had the permit. He told us he did. And then, but nothing more was getting done. And so finally, we came up here and they said, no, there's been no permit. So we went through the process of firing them and then hiring DBK, another company. And they just got all the paperwork.
They actually gave me a permit number, BP 24-0001229. And
Is that correct?
Can you go to the permit screen, please?
He just gave it to me yesterday.
It's not issued, it's in plan check.
Okay.
Okay.
So what does that mean?
Well, The girl that works for DBK, that she's doing all the permitting, she just said she submitted everything yesterday, all the paperwork and everything that they wanted. that she
Okay, so
submitted.
what that means is they're reviewing it to make
Yes.
sure.
Right. She
that- so
said
that they-
it's under review.
Okay.
Yep.
So what the county has requested is that you come into compliance by April 10th.
That shouldn't be a problem.
So if that is not a problem with you, then do you have anything else you want to add?
No?
Okay. Then I'll go ahead and find that the property owner was properly noticed to be here today. The property owner is in fact present, and the county has provided competent, substantial evidence to find that a violation does exist on the property. A violation of Chapter 40, Appendix A, Section 105.1, and I'm going to order that the property be brought into compliance by April 10th at 8 a.m., or a fine in the amount of $50 a day will be imposed.
Yeah. it should
Okay.
be
So
done.
will we be, well,
Well, he'll, once
He'll
he
let
gets the
us-
permit done, he's going to come and get it inspected, anything, after he get it done.
I would hope that your contractor would and would let you know all of that information.
Yeah.
So I would like you also to get a card from
Okay.
Okay, that'd
from
be
Ms.
good.
Hathaway so that you can be in contact with her.
Okay.
Okay?
That sounds
Thank
good.
you.
Thank you.
thank you.
Contact information as well.
Okay.
I'm going to call it let's call
Oh, yeah.
2350 CESM. We have an attorney present, the Lena Della Russo Trust. 2350 CESM. Okay,
Yes, Your Honor.
okay.
Dana
Which one is
Anderson.
this?
And I apologize, Your Honor.
No, you're-
Unfortunately, my clients had a relative die suddenly earlier this week,
Goodness.
and that's why they're not here with me today. We
Okay.
do expect, we had an engineer retained to draw up the drawings for the courtyard in the front, and also for the fence vis-à-vis the side easement off of, I think it's Hunt Club. And we expect to have those ready next week, and we'll send those over to the county for review.
Okay, your compliance date was yesterday.
Yes, Your Honor.
And so how long are you requesting?
Again, I expect that we'll be able to get those plans over next week, and I would hope that we'd be able to have them reviewed and be able to move forward by the next compliance date.
Okay, so that next date would be March 13th. Does the county have any objection to a continuance to March 13th in this case?
The fence has been in plan check for quite some time. They will either need to apply for a variance because it's a corner lot, which I've spoke to, I believe his name is Edward.
Yeah.
In person several times. I've gotten his email, told him what he needed to do in regards to that. They still haven't applied for a variance that I'm aware of. I said, or you can remove the fence so you can be in compliance. I said, there are several options we can look at with the fence alone. The other one's going to require engineered plans and drawings, which, I mean, I can't speed that up.
And
So
if
we've
you'll
been in
go, if you'll go to the picture that shows the fence, I want to make sure that I'm talking about the right fence, the wrought iron fence right there, the wrought
That
iron.
is going to require engineered plans and drawings for the little patio area, which
Okay.
I know they said they were working on. That's one thing, but we've also got a privacy fence.
That on the next picture?
Correct.
Okay.
Right.
That's the issue that's one of the issues that's been held up for quite some time.
My understanding, again, is that and I'm not sure what the variance is needed for, my understanding is that there's a 25-foot easement off of the edge of the road, and that the fence is 27 feet from the edge of the road, and therefore shouldn't need an easement unless there's something that my client is missing.
I had suggested to him, this is how I try to get around things, come in and apply for where your fence is currently, put the dimensions where it's supposed to be. If it's meeting that, then you shouldn't be required to have a variance. But apparently, the drawings are showing something different.
Right, and part of what my client is doing with the engineer is, the engineer came out and measured, and he's going to provide drawings showing that the fence is past the 25
In
foot.
compliance, okay. So then, with all of these things happening, does the county have an objection to a continuance again through March 13th?
To March 13th, that would be feasible.
Okay, all right. Then I will go ahead,
Can we clarify and let Megan speak for 1 second?
sure.
Megan Zanorski, Project Coordinator, Planning and Zoning. Just so we're clear, the fence has to be 25 feet from the property line, not from the right-of-way. So if
Okay.
you're looking at the edge of the road, you need to be looking at the property line.
Okay, so
if it's
25 feet from the property.
from the
line.
property line, not from the edge of the road. A lot of people get confused by
Okay.
that. So if they do not meet that 25 feet from the property line, they will need a variance.
Or they could move the fence.
Or they can move the fence back to meet that
Okay.
25-foot minimum district setback.
Okay, I'll make sure that they're clear on the relevant measuring point. Thank you.
Okay. Then I will go ahead and amend my prior order dated, bear with me 1 second. I know it's in here. My second amended order dated the 18th day of December 2023 to reflect that the compliance date is now March 13th at 8 a.m., and everything else in the order will remain the same.
Thank you, Your Honor.
Thank you.
Appreciate your help.
Okay, and I see we also have an attorney on case 2403 CESM, Brad Samuels.
Good afternoon.
Good afternoon.
Okay. For the record, name is Vicki Hathaway, Building
Vicki,
Inspector for...
Wait,
Seminole
1
County
second, let me go
Building.
ahead
Okay.
and, is there anyone going to provide testimony?
I don't believe so. I've spoken with the
Okay,
inspector, I think.
okay, sorry, go ahead.
Building Inspector for Seminole County Building regarding case number 2403 CESM Brad Samuels at 290 Myrtle Street, Sanford, Seminole County, Florida. The violation charge, Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of the violation, installation of a shed without the required permit. This is the initial inspection that was done on 5/2 of '23, given a notice to the respondent on 5/10 of '23, and a compliance date, which you can see from 5/24 to 8/15 of '23. Follow-up site visits were several of them from 8/1 of '23 to 2/6 of '24, and follow-up inspections via computer starting from 5/23/23 all the way through to 2/8 of '24. Results of the inspection violation remains on the property. This is a picture of the property appraiser's website that shows that Brad Samuels is the owner of the property. This is a copy of a posting that I did on 1/29 of '24 for the hearing. These are several different pictures of a shed that is on the property currently right now. And again, it's hard to see because there's been a trailer that's put into the opening of the right-of-way to where it's blocked it somewhat from being able to get a picture of it on 1/29 of '24. This is a picture of the shed that's on the vacant land dated of 5/2 of '23. And again, on 5/1 of '23, the shed violation remains with no posted, no trespassing signs dated on 8/1 of 2023. And again, the shed violation remains on 8/23 of '23. And this shows no permits here to correct the violations. This is a copy of the permit application dated on 5/26 of '23. And the corrections that are needed for resubmission for NE plan in order to get that pushed through. This is a picture of the Seminole County Chapter 40 Appendix A regarding the permitting process. And the recommendation, based on the testimony and the evidence presented in the case number 2403 CESM, is determined that the respondent is the record owner of the property located at 290 Myrtle Street, Sanford, Florida, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. This is the recommendation to bring the violation into compliance by April 10th of 2024. In order to do that, obtain the permit for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance.
Would you like to?
This concludes my presentation.
Okay. Would you like to submit the electronic case file into
Yes,
the
ma'am.
record as evidence? Is there any objection to the electronic case file being submitted?
No
in
objection.
evidence? Okay.
I've already spoken to the investigator. We'll be in compliance by that date.
Okay.
He's already in the permitting process. A lot of it's been approved. I think there's an issue with the septic. Health was out yesterday looking at it. We'll get everything into compliance, and we will be back in compliance before that date.
Okay, then I'm going to go ahead and find that the property owner has been properly noticed to be here. The property owner is present and represented by counsel. That the county has provided competent, substantial evidence for me to find that the property owner is in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1, and I'm going to order that compliance be achieved by April 10th. 2024 at 8 a.m., or a fine in the amount of $50 a day will be imposed. Thank you.
Thank you. Appreciate your time.
Oh, they've got a copy of it. They have a copy of it.
This is for you.
Oh, thank you, thank you.
You're welcome.
Okay, the next case
But that one has my...
is 2405 CESM, Miguel Devanovich and Rosalinda Guzman.
I'm sorry, which one was this? CESM what?
2405 CESM.
2405?
Yeah, I think it was them.
Okay.
I don't think I did. Okay. Oh. You ready? Okay. Perfect. Thank you. Mr. Guzman? Is that?
No, Miguel.
Devanovich, okay. Can I have you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth? Okay. And did we swear you in when I swore others in?
Yes,
Okay.
at the beginning.
All right, great.
All right, good afternoon. Amy Curtis, E911 Administration, Addressing Supervisor. I have presented a copy of the presentation to the clerk and request it to be entered into the record. Case number 2405 CESM, Miguel Devanovich and Rosalinda Guzman at 146 Leah Avenue, Longwood 32750, Seminole County, Florida. The violation charged is Seminole County Land Development Code, Chapter 90, Section 90.5A and 90.54. The description of the violation is the address numbers are not posted on the structure. Case summary, initial inspection was 3/15/23 and 4/18/23. Notice to respondent, 4/18/23, 6/9/23, 7/19/23, and 8/21/23. And compliance date and extensions, 4/14/23, 5/18/23, 7/9/23, 8/19/23, and 9/21/23. And then to follow up, site inspections were 5/18/23, 7/18/23, 8/21/23, 9/25/23, and 10/19/23, and the violation remains on the property. This is a screenshot of the property appraiser showing that the property of record is Miguel Devanovich Novish, sorry about that, Rosalinda Guzman. This screenshot is the posting of the hearing notice on the property on 1/29/24. This is a screenshot of the address numbers 146 are not posted on the structure, and that was 2/7/2024. And this is a second photo of the same day.
Is there something above the garage? What is?
It's script.
Oh, okay.
It's letter.
Oh,
The address numbers.
in written.
Script.
Okay.
Written script, yes. All right, and then this is the Seminole County Land Development Code, Chapter 90, Sections 90.5A and 90.54. The recommendation, based on the testimony and evidence presented in case number 2405 CESM, it is determined that the respondents are the record owners of the property located at 146 Leah Avenue, Longwood, in Seminole County, and as determined by the property appraiser's records, in possession or control of the property and in violation of the Seminole County Land Development Code, Chapter 90, Section 90.5A and 90.54. Further recommend that the special magistrate order the respondents correct the violation on or before April 8th, 2024. In order to correct the violation, the respondent shall post address numbers 146 on the structure. If the respondents do not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Okay, would you like to submit the electronic case file into the record as evidence?
Yes.
Do you have any objection to the electronic case file that's been presented to you today being submitted into evidence? No. Okay, before you go, let me ask one question. So you have a compliance date of April 8th. Do you have a problem with it being April 10th?
No, I do
Okay.
not.
Okay,
It was already taken care of.
you've done it already?
Yes, it was yesterday.
Okay.
I was renting the property. I moved this month, like last month. So I saw a poster up front on the yard, so I did it yesterday.
So then you do not have a problem with coming into compliance by April 10th?
I do have a problem. I have a small business, but I didn't know how it works. It's my
No, but I
first year,
mean,
so-
if I gave you to April 10th to come
Oh,
into
no, it's already done.
compliance,
So,
then
yeah,
you'd
it's
be
fine,
fine.
it's fine.
Okay.
I was like
Okay.
being here, so.
Okay, all right. Then I'm going to go ahead and order, I'm going to find that the property owner was properly noticed to be here today, that he is in fact present, that the county has provided competent substantial evidence to find that there has been a violation of Chapter 90, Section 90.5A and B of the Seminole County Code, and I'm going to give you until April 10th, 2024 at 8 a.m. to come into compliance, or a fine of $50 a day will be imposed. Okay? Thank you.
Thank you.
Compliance hearing 22103 CESM, Thomas Courtright.
How are you?
I'm not calling any of the ones that aren't present yet. I'm going to call those last, but.
Okay, I'll read through the hearing notice. For the record, name is Vicki Hathaway, Seminole County Building Division, Inspector for Seminole County Building Division. It's a compliance hearing for 22103 CESM Thomas J. Courtright Jr. at 5675 Deer Path Lane, Sanford. The violation, remodel of an interior garage into an apartment, including plumbing, electrical, HVAC, and new windows and doors. Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. The case was originally heard by the special magistrate on December 8th of 2022, and an order was issued giving the respondent a compliance date of March 9th of 2023. On March 9th of 2023, the special magistrate issued an order extending the compliance date to June 7th of 2023. On June 8th of 2023, the special magistrate issued another order extending the compliance date to August 10th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on August 15th of 2023. On September 14th of 2023, the special magistrate issued an order extending the compliance date to November 17th of 2023. At the request of the respondent, this case was heard on November 16th of 2023 by the special magistrate, who issued an order extending the compliance date to February 7th of 2024, with a meeting of February 8th of 2024. The estimated administrative cost to proceed this case, or process this case, to date totals $936.32 for both the inspector and the clerk. Recommendation that the special magistrate board issue an order constituting in the lien in the amount of $50 for 1 day of noncompliance through and including February 8th of 2024 at $50 per day, and the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after February 8th of 2024. I did speak to Mr. Courtwright. We've been in constant communication. We've got one permit that we're waiting on to get issued, and that's going to conclude my case, and I'll let him speak on his behalf.
Okay, Mr. Courtwright, let me go ahead and swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
I just need an extension. Again, we're waiting on an engineer right now. I've got the engineer already. The drawings are stamped. It boils down to me going and picking them up and paying a lot of money right this second. Unfortunately, I've dished out a lot of money on this property with the other various permits we've dealt with, so I'm just looking for an extension of another 30 to 60 days to get him paid and get the permit applied for.
Okay, does the county have any objection to an extension being provided?
No, ma'am. He's constantly worked with us and stayed in touch.
Okay, are you asking for 60 or 30?
I would like to go to April, just because I don't know how long it's going to take for the permit approval process to go.
So April 10th, is there a concern on the part of the county with April 10th?
No, providing we can stay in constant communication if things are kicked back for some reason, that he will be aware, because I pretty much babysit these cases.
She's tired of talking to me. I talk to her every week, it seems like, I promise.
Okay. All right, then I will go ahead and amend my third amended order dated December 22nd, 2023, and order that the property be brought into compliance by April 10th at 8 a.m., and everything else in the order will remain the same.
Thank you.
Thank you.
Okay.
He's going to probably be next.
No, I do have Scott and Evelyn McCurdy, and Mr. McCurdy's here. 2341 CESM, Scott and Evelyn McCurdy. Mr. McCurdy? Can I have you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
So help me God, yes.
Okay.
Okay, for the record, this is a hearing for cost only. Name is Vicki Hathaway, Building Inspector for Seminole County Building. This is in regards to case number 2341 CESM, Scott and Evelyn McCurdy at 1110 Lake Mills Road, Chuliota. The violation charge was Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on April 13th of 2023, and an order was issued giving the respondent a compliance date of June 8th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on June 21st of 2023. An affidavit of compliance was filed by the inspector after reinspection on January 24th of 2024. An estimated administrative cost to process this case dates to total of $592.19 for both the inspector and the clerk. The recommendation is that the special magistrate issue an order reducing the fines to the administrative cost of $592.19 and order these costs to be paid within 30 days, or the fine will revert to the original amount of $11,500 and constitute a lien on the property. This concludes my presentation.
Okay. Mr. McCurdy?
I mean, I don't have anything to say other than we're in the process. The gas inspection took place today. The electrical inspection, I believe, is taking place today or tomorrow. And hopefully this will be over with next week.
Okay.
All the permits are in play.
Okay, so the permits are in place, but it took $11,500 worth of daily fines accruing for the permits to be put in place. So were there issues with compliance?
Well, the issue is the electrician telling me he had a permit in place, and he didn't. And to be honest with you, I didn't even think about the gas permit until the inspector came out last week and said, well, where's your gas permit? And I went, okay. So I've gotten that, and it's been inspected, and it's passed. So anyway, I mean, I have no excuse. It happened, and so.
Okay, so the county is actually asking to reduce the fine that accrued, the $11,500. They're asking to reduce it just to their costs, $592.19. Can you have that paid within 30 days, or do you need longer?
No, I can pay it.
Okay, then I will go ahead and reduce the fine. I'll amend the order that was prior entered and reduce the fine to $592.19, which represents the costs that the county incurred in this matter, and this is to be paid within 30 days, and if not paid, the fine will revert back to the $11,500, and it can be recorded against the property to constitute a lien.
How do I get that money to the county?
So when you receive the order, there'll be directions on where you pay that to.
Okay.
But I believe it's right here. Once they get the order, then they can accept your money, but they can't accept your money until they get the order.
So I couldn't pay it right now if I wanted.
Well, if you all can do that,
It's up to them, not me.
can you give
I mean, it
him
would have to be with
something?
a credit card. I don't have that much cash on me.
It has to be check or cash.
Okay, all right.
Okay, so we'll get the order to you, and then you would come back down here to be able to pay it.
So I have to come here to pay it?
No, you can mail. If you're going to pay by check, you can mail.
Okay.
I don't recommend you mail cash, but,
No, I would not do that.
okay.
Okay.
Okay,
All right.
thank you.
Thank you.
Uh, 2359 CESM All Stars Assisted Living Incorporated.
Thank you.
I can go ahead and have you raise your right hand. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
For the record, name is Vicki Hathaway, Building Inspector for Seminole County Building Division. This is in regards to case number 2359 CESM All Stars Assisted Living, Inc. Ilsa Guerra Morales at 1131 West Lake Brantley Road, Altamont Springs. Violation, installation, and renovation of a two-story structure. Seminole County Code, Chapter 40, Appendix A, Section 105.1. Construction without the required permits. On September 14th of 2023, the special magistrate issued an order giving the respondent a compliance date of December 15th of 2023 and scheduling a compliance hearing for January 11th of 2024. An affidavit of noncompliance was filed by the inspector after reinspection on December 15th of 2023. On January 11th of 2024, the special magistrate issued an amended order extending the compliance date to February 7th of 2024 and scheduling a compliance hearing for February 8th of 2024. The estimated administrative cost to process this case so far to date has been $855.28 for both the inspector and the clerk. Recommendation, the Special Magistrate Board issue an order constituting an lien in the amount of $50 for 1 day of noncompliance from February 7th of 2024 through and including February 8th of 2024 at $50 per day, and the fine shall accrue or continue to accrue at $50 per day for each day the violation continues or is repeated after February 8th of 2024. And for the record, I just wanted to let you know, as well as I spoke to the property owner, I reached out to the contractor who was here last month for the hearing, who said he could do it within 30 days. I checked on his permit that he had submitted last week by Thursday, and Friday I contacted him on Thursday and told him that he promised the magistrate that he would bring her into compliance. When I looked at the application, I told him we've already got issues getting through the gate. And he was down with COVID at the time, so I told him contact me the beginning of this week so we can go over what needs to be corrected with coming through the paperwork for the gatekeeper. And I have not heard from him since.
I spoke with him yesterday, and he mentioned the blueprint that he presented was including everything that was there before, because when I bought this facility a year ago, everything was there. The only thing that I did was replace. I didn't know that this was a property that was not in compliance, that wasn't with a permit. So I acquired a problem, which I have to solve because now it's my problem. But he mentioned something that I'm not sure if I'm understanding correctly about the indwelling, something like that. So I have that originally the picture was taken by the county about yes, there was a kitchen in place, there was a bathroom in place. So he submitted the paperwork, yeah, those pictures.
Excuse me, real quick. When I looked at the application, we have a storage area, okay, which I don't think either one of them are understanding, and I had to explain to him, she bought something that was unpermitted, and now it's hers. You promised you'd bring it into compliance. He's applying for repairs. This is not a repair. We went from the bottom of a frame job in a storage unit for storage only to where apparently the previous owners had fixed the inside to be an accessory dwelling. So I tried to explain that to the owner here and also to the contractor online, and he's like, well, there's nothing else to pick. I said, well, here's the name of 3 people in permitting. Contact them, ask them how to enter this in, because he's submitting it as a repair only. This is a complete build-out that she acquired when she purchased the place.
So is, it was fully built out?
Was
when
fully
you-
built up.
Okay.
Only I did was replace the carpet, old carpet for new carpet.
Okay, is an accessory dwelling allowed?
Our last inspection we had, it was a storage unit. It failed the frame. Next thing I know, we get a notification from the sheriff's office, the code enforcement, that there's somebody making repairs to this accessory dwelling that apparently a neighbor had called in. So they referred it to us because it's building. So to her, in her mind, she's making repairs. She bought it this way. It wasn't that way when we last inspected it.
Okay, but is it allowed to, is an accessory dwelling allowed on this
She
property?
can have that there, from my understanding. However, I don't think we're going to get through the paperwork trying to get into the building as to what we have, because he's not understanding that this is an acquired issue that she inherited.
Okay, so what they're telling you, what the county is trying to explain is you have to get full permits for this as if this did not exist. This is not just a repair. So you can't, you're not getting permits for just the work that you did. You have to get permits for all the work.
The whole building?
Yes.
The whole building.
So what he did with the blueprint doesn't represent what is in place?
No, there is no blueprint that he submitted that I have. I have paperwork that shows really an incomplete application, and that's when I tried to explain to him. And he kept saying, well, she's only making repairs. And I said, you're not listening to me. This was a shed. It was approved as a shed. It wasn't built out. We failed the frame, which means there was no interior anything but a frame and a shell. Now it's a complete apartment that she's bought. She probably bought it for that reason, because it is a nursing home in the main structure, thinking she could live on site.
So, but you just have to go through the entire permit process. How long is it going to take her?
I don't know how long that's going to take. If we can get the paperwork submitted properly with the correct drawings as to what we have, we turn out permits pretty quick, but I can't gamble on another person's contractor. And when I call him and tell him this, it's not registering with him.
Possibly consider getting a different contractor that understands that you have to get a full permit, like from start to finish. So if she were to get someone new to come in to fill out the proper application and submit the proper documentation, that would probably take 60 days, and then...
I think that if we can, even working with this contractor, I understand he had COVID. He probably didn't want to deal with anything at the time, and I told him, please contact me at the beginning of the week, because I need to tell you how to get your paperwork through. Because I had people look at it already, and it's stopping at every stop point, and I'm like, this is not going to fly. We're not going to be done in 30 days. I don't like to hang my hat on anybody getting anything done in 30 days because I don't have control over it.
Right. So in this particular situation, in light of the fact that it looks like even what's been submitted to you is not going to be proper and it needs to be redone, what about June 12th?
I would say that would probably be a good shot at that.
Okay.
I don't think Ms. Morales has that understanding of what she needs to get done, which is why I told the contractor I'd reach out to him directly, and I have his card here and documented that we did talk.
Okay.
I will probably contact him again, even though it's not my job to do that. But I'd like to see her get compliant and be able to have her building.
Okay, are you understanding? Okay,
Yes,
so
yes.
so the county is actually going to forego the cost at this point. They're not going to seek costs anymore. They will give you until June 12th to come into compliance.
Okay.
But you've got to stay in constant contact with Ms. Hathaway.
And the contractor,
And
please.
your
He's not
contractor,
mine.
having your contractor. And if you can explain to him that this is not just a repair job. You have to act as if you constructed this entire building. Okay?
Yeah.
Okay.
Hasn't been easy to find somebody who do a job like this.
Especially taking on someone else's work. I understand.
Yeah, so I would like to work with him as is possible, because the issue, took me for only 6 months to find him, or somebody who say yes.
Okay.
Yeah, so I would like to continue.
I don't have any say in that. I feel like he is earnest at what he wants to do.
Okay.
But acting on it and saying it are two different things, and she's the one who's going to ultimately.
Right. I just want to make sure that you're comfortable with him. I'm not telling you that you have to change contractors. I'm just saying if for some reason he's not following through and he's not doing what he needs to do, and based on what your understanding is here today,
Yeah.
you might get to a point where you want to change contractors. But absolutely, if you're comfortable with him, stay with him, but just try to make sure that he understands what has to be done and that he remains in constant communication with Mrs. Hathaway.
So I will need the specific paperwork so I can present it to him, that that's the way he's supposed to turn in the permit?
I'll probably be in touch with him at the beginning of this week coming up. I do need to enter in the cost for evidence because they're a little bit different than what we have on our actual agenda here for the PowerPoint.
But we're going to amend the orders, so you don't need to submit them at this time.
And I'd much rather probably communicate with her contractor, and then I catch you up with that at that point in time.
Okay, great. So I'm going to go ahead and amend my prior amended order dated January 16th, 2024. And I'm going to extend the compliance date to June 12th at 8 a.m. with all other parts of the order remaining.
Thank you.
Thank you.
Thank you.
Okay. Case number 2368, CESM, Innovo Properties LLC, Jason Shaka. Yeah.
Incorporated. I am LLC.
Let them know, because they have to, because it's on the property appraiser. You ready for me to start?
Yes.
For the record, the name is Vicki Hathaway, Seminole County Building Inspector for Seminole County Building. This is in regards to a lien hearing for case number 2368 CESM Innovo Properties LLC. Jason Chawa, is that?
Chaka.
Chaka, at 1230 Woodmere Drive, Altamont Springs. Notice of violation posted was installation of a fence, 2 AC units, enclosed garage and carport, and multiple accessory structures and backyard consisting of a box truck which was turned into a living quarters, wood shed with tarps over it, and miscellaneous type accessory dwellings in the back of the property, aluminum carport with tarps over it. This case was originally heard by the special magistrate on December the 14th of 2023. An order was issued giving the respondent a compliance date of February 7th of 2024, with a compliance hearing scheduled for February 8th of 2024. An estimated administrative cost to process this case to date right now are $752.27 for both the inspector and the clerk. Recommendation that the Special Magistrate Board issue an order constituting a lien in the amount of $250 per day for 1 day of noncompliance from February 7th of 2024 through and including February 8th of 2024 at $250 per day, and the fine shall continue to accrue at $250 per day for each day the violation continues or is repeated after February 8th of 2024. This concludes my case.
Okay, and any attempt whatsoever to get permits?
I don't.
There was back in November.
Wow.
I think in November.
Let me go ahead and have you, swear you in. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Can you state your name, please?
Jason Chaka.
Okay, and can you tell me your affiliation with the case?
I own Innovo Properties.
Okay.
So I bought the property and had all these issues. Initially, the first issues I had to deal with was the squatters that were living there. I just kind of had to deal with them for months. Even recently, I think I had like a break-in. I know there was like a drive-by this one time. They asked me, hey, does so-and-so still live here? I'm like, no, he left already. So like that property, I don't know what went down, but like that property's like still associated with like other people, I guess. So people just try to get in the property, I guess. But yeah, my issue was just like the lady before me. She have issues getting a reliable contractor. I know that I had a contractor and he began applying for permits back in, I believe, November, sometime in November, but he never submitted any kind of forms or anything.
Right there.
So I know that went nowhere. Today, I have another, I have someone who tried to contact Vicky. I figured you'd be busy today, but I know she tried contacting you. She actually seems straightforward. I think she might actually get the job done. I know that you guys want permits. Like I said, I think she's the one who will actually get those permits. She just asked me to. She's going to apply for those permits either today or by sometime this week or in the next week, so we can begin to put this behind me. Because I got another contractor last month. He told me he was going to apply and everything, and then just never talked to me again. Like I said, back in November, he started the application and then just said nothing, disappeared.
So the problem that I have is that you're the property owner and you've made absolutely no attempt yourself to contact Ms. Hathaway and communicate any of this to her before today.
I know I've talked to Ruth and Vicky was CC'd in emails because there was the structures in the back, those have been taken care of.
Like removed, is that?
Yes. The aluminum carport, I know she said the box truck was a living quarters. It wasn't a living quarters, but it was there. That was removed. There was a red truck back there. That was removed. The wooden structure in the back, completely removed. The aluminum carport, that was taken down.
What about the air conditioner units?
Those were taken down, but I just had to patch them up before people start trying to break in again.
If I can go ahead and speak, I spoke to Mr. Chaka. The beginning when he purchased his property, he was not willing to move forward with his building permits because he was working on code violations from the sheriff's department. Told me he had squatters on the property and he didn't have access to anything. Whatever was removed out of the backyard, we've never been notified to come back there and look. And since then, you can see where the house has been modified from 129 of 24, construction's still going on, to where it looks like they're trying to make it into multiple dwellings in the main structure.
So there are windows now where there weren't windows before.
And a new door where there wasn't a door.
Can I speak?
And a
on
new
that?
fence.
Okay.
That's gone up.
So the fence,
No, speak to the doors and the windows to me.
okay. So I know it's kind of hard to tell in that picture with the windows. But literally they just kind of put up plywood and some wood there.
Doesn't matter. It doesn't matter what you, you're doing construction without a permit. So it doesn't matter whether it's.
Well, that was more like demolition, like it wasn't like truly like attached to that house. It was, that's why it's kind of hard to explain. It wasn't truly attached to that house. The stucco kind of was on the corner, but that's about it.
That's a complete modification of the structure.
No, that was originally there. That's all original right there. All that brown, that door, it's all original.
It was the enclosure that was the violation. Now the
Yes.
enclosure is morphing as time goes on.
Like I
So
said,
the enclosure's been removed?
The enclosure was a carport originally.
so that's
the
what
garage.
that's what I was told from you guys. But as far as I see, like it's all been enclosed for I think the 80s. Because it had like the really old. Yeah, all that stuff is old, like from the 80s.
Well, the picture is obviously.
I know, that's what I'm saying. I don't, like, you can't really see it, but like this is the window, correct? This is like the little soffit area. They literally just put up some plywood here and like just close it off. I guess for privacy concerns, I don't know.
So you removed that?
I removed that.
Is a demolition permit required for something like that?
Yes.
Yes, I didn't know that. I just wanted
But-
that removed so I can actually have access to that door.
But I think when you're under violation, to continue to work on a structure is a huge problem. So that, I'm certain that you sat through most of the hearings today and heard me say over and over again how communication was important, and ignoring them and just continuing to work on the structure is not what gets help from me. So I'm having a hard time considering giving you more time, because I feel like you're just going to ignore it anyway, and I'm going to be right back here.
I'm not trying to ignore anything. I have my own life issues. My mother just got diagnosed with cancer last month, so she literally just got surgery like a week and a half ago. Dealing with that, now she's about to go through radiation. On top of that, my little brother, we're trying to work with him on his seizures. So like I got my own stuff. I'm a student, full-time student, just trying to get by. It's hard for me to get the money for the permit, but like, you know, to take something down, like I'm like, okay, I can do that, you know. So I am trying to do the best that I can with a limited amount of resources.
Are you living on the property?
No, not this property, no.
Okay.
I'm living with my parents right now. Again, I talked to a contractor. She told me that she's been in full contact with me. I only got in contact with her like 2 days ago. But
What's her name?
Her name is Ivy. Well, that's like her nickname. Her actual name's kind of difficult to pronounce. It's like Ivelisse Villamar.
Can you spell that for me, please?
Ivelisse. That's her first name.
Okay.
Her last name is Villamar.
Okay, and she's a licensed contractor?
Yes, she's a licensed contractor. The other two licensed contractors that told me that they were going to help me, they just disappeared on me.
Okay.
I don't know what to say further from that with those contractors. I thought they were there to help me, but apparently not.
So
she wants 180 days. This is what she told me to tell you, because it was such short notice. She told me she wants 180 days to bring everything into compliance, to get the permits, and then in case that she needs to talk to an architect or a construction or engineer, she wants to have that time to be able to get everything in compliance. So she wants 180 days. That's what she told me.
Okay, so that's not reasonable.
She told me the 180 days, like if it was just like a simple permit to pull, that's fine, that she'll be able to do that soon. Like I said, she's applying for the permits now. But she wants 180 days to get the job done.
Okay, and we're not asking you to get the job done. I'm asking you to get permits.
Okay, and if it's just the permit portion, she'll start applying. I don't know how long it takes to actually get the permit.
I don't know. Do I need to post a stop work order until the permits are issued? Because somebody's constantly working on that.
Not constantly. Like I want to paint it, but I haven't gotten the time to paint it. Because that's just primer right there. I wanted to paint it.
No, I know it's paint, but what I'm saying is we went from the previous structure here to now the windows and another door.
I know. I know that's, like I said, I know it sounds really weird. Like I don't know why they just they just kind of boarded that little section up and.
But the work needs to stop until permits are issued.
Yeah.
That's what I'm trying to convey.
Okay. No, I understand. If she can have the time that she needs, because she's completely brand new in this whole situation, in this whole case. If she can get the time that she needs to apply for the permits, and that's all I'm asking for right now.
Okay, so what I'm going to do is I'm going to give you 60 days on the permits.
Just to open the permits?
To get a permit.
To get a permit, okay.
And
I can do that.
I'm hoping you can.
I hope I can.
If you are unable to and you have to come back here for some reason, I do not want to hear that there was any work being done, any work
Okay.
of any kind. I don't want to hear that you haven't communicated with Ms. Hathaway throughout this process,
Okay.
or that your contractor has not. If your contractor, this contractor, decides after you call her after this hearing that she can't do this, then you need to go find another one.
Of course.
So we will come back on April 10th, and hopefully you'll have permits. If you don't for some reason, then we'll, of course, make sure that any of these other things have not been occurring, because I will not be as generous if you have to come back a third time.
Understood.
Okay?
Can I ask for his information for the record, and that Mr. Chalka get my card and stay in touch with me?
Absolutely. So can you provide your address, and then I'll ask that privately you provide your telephone number to Ms.
Also, I need to
Hathaway.
verify that the structures have been removed from the back.
Okay,
Because
so,
I can't verify that.
The structures, I've sent a picture. I don't.
We don't take pictures, I have
So
to
if-
see it.
Oh, okay.
if you'll
Gotcha.
schedule a time, she's going to give you her
Okay.
card, you schedule a time, take her onto the property, let her verify herself. That's how we verify compliance,
All right,
okay?
understood. I don't. It looks kind of ugly. Could I at least paint it at some point?
We don't care if you paint it, but
Okay.
Painting doesn't require a,
demolition and construction has to stop.
Okay.
Right.
Yeah. All right,
so,
all right.
yeah, I mean, if you
that's fine.
paint it, but then you don't get a permit to do what it is that you've done, and
Yeah,
you've got
okay.
all of that,
That's
just
fine.
keep that in
Yeah,
mind.
yeah, that's fine.
Okay. Okay, then I'm going to amend my prior order.
Can-
Yeah,
I was gonna say, can I ask a question?
sure.
Is this being turned into a multi-dwelling?
I hope so in the future. It was already at some point a
Or is
multi-dwelling.
it being built to be built as a multi-family dwelling?
No, it was already like a multi-dwelling.
But it's
it was-
single-family.
And it has two power meters, electric meters. At some point, it was a multi-family unit.
Is
and
that
I know
permitted on this zoning,
It is.
with this zoning?
Yeah, I spoke and asked about that because that's what I wanted to do in the near future.
Drive.
But I don't even have the funds for it right now, so.
It appears to be being turned into a multi-family dwelling.
Is it allowed to be turned into a multifamily dwelling under that zoning category?
Woodmere.
It's R2.
Which means?
Good afternoon, Megan Zanorski, Project Coordinator, Zoning. It appears that R2 is a 1 and 2 family dwelling district. It would be reviewed on its merits. If there is 2 meters there, any alterations to the interior would need a permit and would need to be reviewed for zoning compliance.
Okay, so just make sure that you remain in contact. It does appear that you can have, that it is zoned properly for multifamily. So just make sure that you remain in contact with the county and that each step of the way you're doing what the county needs you to do to be able to develop in that manner.
Okay.
Okay? Okay, so I'm going to amend my order. I believe you've gotten the contact information that you need?
Yes.
Okay. I'm going to amend my prior order dated December 18th, 2023, to reflect a compliance date of April 10th at 8 a.m., and everything else in the prior order will remain in effect. Okay?
All right.
Thank you.
Thank you.
Thank you.
2366 CESM, Efrain Lima, Kelly Andres.
Good afternoon, Your Honor.
Good afternoon.
For the record, McGregor Love at 215 North Yola Drive from the Lowndes Law Firm.
Okay.
Good afternoon, Officer Hill, Seminole County Sheriff's Office Code Enforcement. I'm submitting a copy of this PowerPoint to the clerk as Exhibit 1.
Okay, wait a second. Do we have any objections to? Why don't you go through the PowerPoint first, and then let's see if we want to submit it into evidence after you've done that.
Okay.
Were you sworn in?
Yes, ma'am.
Okay. And will you be providing any testimony by any individuals?
Yes, Your Honor.
Okay, can I have, you don't need to swear in, but will you be providing? Do you solemnly swear or affirm that, do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Go ahead.
This is case 2366 CESM, Efrain Lima and Kelly Andres, located at 3125 Lowry Drive in Oviedo. The violation charge is Seminole County Land Development Code, Chapter 30, Part 7, Section 30.122. Storage on a vacant parcel is not a permitted use or use allowed by special exception in an A1 zone. At the November 16, 2023 hearing, an order was issued by the special magistrate continuing this case to January 11, 2024. Hearing on January 11, 2024, the special magistrate issued an order extending the compliance date to February 7, 2024, with a compliance hearing scheduled for today. The estimated administrative cost to process this case to date total $618.60 for both myself and the clerk. The recommendation is a special magistrate issue an order constituting a lien in the amount of $150 for the 1 day of noncompliance from February 7th, 2024 through and including February 8th, 2024 at $150 per day, and the fine shall continue to accrue at $150 per day for each day the violation continues or is repeated after February 8th, 2024. So the order was to open up the property by 8 a.m. on February 7th. Myself and Inspector Vicki Hathaway with the Seminole County Building Department responded out yesterday. Before approaching the property, Inspector Hathaway called Ms. Andres and left a voicemail. She called, she didn't answer, voicemail was full, so she couldn't leave a message. So we continued to the gate to see what we could see from the gate because the property was not open, and also I conducted an inspection at the apartment complex neighboring next door. Then about 11:14 yesterday morning, I called and left a voicemail on Ms. Andres' cell phone, and then I called Mr. Lima and left him a voicemail. Mr. Lima did call me back shortly after, and I informed him for the reason my call was to do the reinspection, and I wasn't able to get a hold of anybody in the morning, so I said, can we do an inspection in the afternoon? Mr. Lima was very excited, stated that he had received his CO and that they had moved onto the property. So he had come to my office as well as he came up yesterday as well to what he said was a copy of the CO. And so I told him that I would submit this into evidence today. I told him I wasn't a building inspector, so I couldn't testify this was a CO. Ms. Andres said, she asked if this could be considered as a good faith effort to come into compliance. And I said, well, I'm not a building inspector, so I can't testify to that this is a CO. But if the building department states that this is a CO and it's a permit and they are allowed to live there, then the accessory structure violation would go away.
Okay, do we have someone from the building department that can provide testimony related to whether there is a CO on this property for someone to live on it?
Do you want to see this as well?
Yes, please. So do you have a copy of what they're providing me?
Yes,
This-
yes,
okay.
and we have no objection to that being entered into evidence.
Okay, and do you have any objection to her electronic case file being entered into evidence?
We do not.
Okay. I'll accept the electronic case file into evidence, and let me see this document before I... Mr. Pike, have you seen these documents? Would you like to provide those to him?
Yes, I saw those yesterday when they were up at the counter. This is Bob Pike, building official, Seminole County.
Okay, and can you tell, are these COs for them to live in a structure?
No, they're not. This is something that the property owner had got from an engineer stating, and they were at the counter yesterday stating that they were getting a CO based on this report here that they had a private provider. And through our records, we have no record of being submitted anything for a private provider for this property. The building permit is for the metal building, and I did renew the permit last year, but we've had no inspections. And there are still outstanding inspections. I told him that in order for a private provider to do this kind of stuff, we would have record of it, which we did not. And he claimed otherwise, but we don't have any records of it. He was saying something about 30 days, and I said, well, you had submitted for a revision for the work inside the building, and we did do plan review comments on it and sent it back to them. And there were no responses back, so that's kind of why the permit expired, from lack of activity. But he took this upon his own self, and there's a process by private provider in the state of Florida, and none of that has been met, and we've never been notified of any of that. So I said there's nothing I can really do for you on that.
Okay. All right. Does the county have anything else at this time that it would like to submit?
That concludes my presentation.
Okay, thank you.
So again, McGregor Love, thank you for having me here today and my clients. Your Honor, I watched the last hearing, so you'll be delighted to know I'm not going to subject you to an evidentiary hearing today. I've just been brought in by the property owners this week, and that wasn't because of any sort of last-minute planning on their part. They just believed that they had kind of done what they needed to do in order to get a CO. They really did believe that. And if you'll permit me, I'll kind of walk you through where you left it on the 11th of last month to where we are today. As far as I was aware from listening to the recording of the meeting, there seemed to be sort of two paths for compliance. And one is the permitting of a principal structure that meets the zoning standards, and the other is removal of all of the stored items. They proceeded down the former path, and they did so using a designer on an expedited fee that put together the packet that went out to the county on the 29th, the certificate of completion. They talked to this designer yesterday about the third-party provider feedback they received from the building department, and that he provided a letter that explained a conversation he had with the previous building official that apparently did not go over this private provider process. I'm not going to ask you or anyone else here to litigate that issue or to make a ruling on it. I'm simply trying to frame it to help you understand kind of what the open questions are and what my job will be to get my arms around as I kind of work them through this process and towards compliance. So we need to figure out what they need to do in order to actually properly get a certificate of occupancy, whether it's this process that seems to be a newer form or something, some other additional paperwork we need to fill out to make it all in compliance and fully permitted.
Okay, so I don't know what the documents are that you have, and I personally would not recommend that you follow something that someone else gave you. I think if the building official is telling this is the way that it goes and this is how Seminole County does this, I think it also is in the Florida statutes with respect to use of private providers for inspections. So I think the building code's pretty clear about how it's done, but then each jurisdiction can adopt procedural, a process for how they go about implementing that statute. So I think if you would need to follow Seminole County's requirements, and it's my understanding that your client is an engineer himself. Is that correct?
Neither one of us are engineers.
Okay, and what does your client do for a living?
Electrical contractor.
Okay, so he is a contractor, because the other thing I think you need to understand is each time that they've been before me, they have acted as though they have no knowledge of how codes work. So I find it interesting that he's here as an electrical contractor and doesn't understand how the building code works. Nonetheless.
And look, I listened to that whole hearing from the last time, and I understand there was some back and forth. The reason that they have me here today is to try to sort all of this out for them and to be here to guide them through the process.
Okay, so my advice would be that they follow what Seminole County is telling them to do.
And I'm not arguing
Okay.
that the intention is not to do that. And I guess the ask at this point is we don't want to go around any requirement that needs to be fulfilled. We would ask for time in order to, before fines begin to accrue, where we can go through the correct process and get this accomplished.
So I am inclined to do that under one condition, that they allow the county on the property. They have at every step of this process for multiple times. They have said no. I mean, they've evaded the address question. They've evaded someone accessing the property to make sure that they're in compliance. And one of the main things, if you watch the tape, you know that I said, is compliance is achieved by the officer stepping foot on that property and seeing what's been done. So at this point, I'll agree to amend the order and give them time if the agreement is reciprocated, that the county will be permitted to go on the property to verify compliance.
And do you mind if we speak about this? Because we haven't talked about this in length. If you just give me a moment. Let me just ask for, I apologize for the delay, Your Honor.
No, that's fine.
Just for clarification, so they're just in a position where they've gone down this third-party provider route. So if they were going down the latter route that I spoke about, which is removing all of the, items on their property, I would agree that they would have to have a on-site inspection, but the first route is more of a technical compliance route. And so if they obtain that CO and they go through the formal, the actual proper process under the county's code, would there need to be an inspection of the property in that instance?
No, there wouldn't, but then I will not. I will start the fines today. And that is because I made it perfectly clear at the last hearing that they needed to keep in contact or they needed to come into compliance. They did not do that. The county had to contact them. They made multiple attempts to meet on the property, to come into to make sure that they were in compliance. And instead of contacting them, they show up with a piece of paper that wasn't appropriate, and the individual who did it should know that it wasn't appropriate either. And this is nothing against you, and I feel horrible that you are put in the middle of this situation. No. I know your firm, you come from a very professional firm, and so I know that you are here doing nothing but what you believe is in the best interest of your client. But unfortunately, your client has shown me personally, as the magistrate, nothing but that they are not willing to follow the rules in Seminole County. And so for that reason, they have a choice. I will extend for the amount of time that you are requesting, regardless of whether they're going to use an outside inspector, as long as they allow the county on the property to ensure that compliance is there. And that compliance means that we get to see what structure it is that they're saying is their dwelling, and we get to see what's going on that property. I think if you listen to the last hearing, you also know that they were digging a well without a permit on that property. So there are multiple things going on that have continued to cause me to be concerned with their ability to comply with the law. And so it's one or the other. We will start the fine today, or we'll give them the time that they are requesting. Even if the time that they're requesting is more than I would typically give, I'll give it. But they have to allow the county to go on the property to verify the compliance.
If you could just afford me maybe 30 more seconds to talk that over with them, I appreciate it.
No, take your time.
Madam Magistrate.
Sorry.
Just when there is a moment, Megan from the county has something to say as well.
Okay. Liz, are these the same? Like you gave me one, and she gave another. Do you think they're? Oh, you need one. Okay. I'm trying to get things in order to. Oh, okay.
Thank you. I appreciate your patience. There is another separate, I believe, building code violation that's pending for interior work that's been extended to a date certain in July. We're trying to find that date currently, but it may make sense if the county supports it to have both of them have the same compliance date with that condition attached.
Okay, so let me hear from the zoning official.
Mine's simple, Your Honor. There was actually a scrivener's error in the affidavit that was submitted at the last hearing.
Okay.
It had the year of 2023 when it was actually 2024, so I'm just submitting a corrective affidavit.
For the file?
For the files,
You're
rather.
permitted to do that without, that's fine.
I just wanted that.
Okay. So do you have what that July hearing date is for the zoning hearing, the compliance? For the July hearing, so then it would have been July 10th. Yeah, so July 11th is the hearing, July 10th would have been the... So does the county have an objection to making these two synonymous, since it appears that they are trying to achieve receipt of building permits to be able to live on the property? If all of the order dates are synonymous, being July 10th, and they're going to allow the county on the property to verify all of the compliance, that's not an objection on their part? Can someone remind me, once he's listening again, can someone remind me what the hearing that we continued to July 10th, what that violation was? Internal construction? It's building?
Building issue.
It's unpermitted construction.
Okay. And is there well, when he comes back, I'll want to talk to the building. I have questions about the zoning, so.
I apologize. I
No.
didn't know that I was supposed to be up testifying on this case today.
No, you're fine.
Okay, we agree with that.
Okay.
Yes.
So let me make sure that we have, can I ask you a couple questions about zoning? Sorry.
Yes, ma'am.
So is the zoning proper for this piece of property to have a dwelling on it, people living on this property?
Yes, ma'am.
Okay.
If it's properly permitted.
Okay. Then I have no concerns with continuing this case to July 10th, with the caveat that the county will be permitted to go on the property on or before July 10th to verify compliance. So if you contact the county prior to July 10th to verify compliance, to come out there, they can certainly do that, but on or before July 10th. If they do not allow the county on the property, the $150 a day fine will revert back to today's compliance date. Okay?
Understood.
Okay. Okay?
Thank
I'll
you.
go in. Thank you.
If I'd like to speak on that.
Do you want to,
Mr. Pike wants to speak.
do you still, okay, wait, the building official is,
I want to speak for clarity.
okay?
Since how they thought that they had a private provider, they missed the boat on that per statute. It has to be at the time of permitting or 2 days prior to the first inspection, so they've missed both of those boats. So they don't have that opportunity now. So What they need to do is get their revision approved that shows that they have living inside this barn in order and get it approved. We did do a review on it and sent them comments and have not heard anything back on that. So in order for that to proceed, they will have to get that approved through the permitting process. And from my understanding is they're already living out there and have applied for homestead.
Applied for homestead on a property without a structure that's been permitted. Does the property appraiser approve the homestead exemption without a permit in place?
Good afternoon, Your Honor. Megan Zanorski. I called the property appraiser this morning with the intent of finding out whether or not they had an agricultural exemption application in, because that's been something that they've asserted multiple times, which they do not have an application on file for this parcel. As I was looking at the property, I noticed on the property appraiser's report that it said approved for 2025 homestead exemption. So I made a call to the property appraiser's office, and they said that it had been, in fact, approved for homestead. They do wait for Seminole County to release a list of some sort, I'm assuming from the building division, where we have issued a CO for occupancy. So if they do not obtain CO, they would not get homestead, but they have approved, or they have submitted. And one of the questions on the application for homestead is an occupancy date that they do have to complete.
And do we know if that, did you see the application?
I was told that that was an application that was not of public record by the property appraiser's office, so I do not have a copy of the application.
Okay. Can one of your clients tell me the date that they stated that they were occupying the property?
It seems that they don't recall actually putting a date on the application, but we can provide that information. They're going to go back and review the document that they submitted. I certainly believe that that's a question on the application. I don't think that's being made up, but they don't recall what date they specifically put. They were under the belief, as a general matter, and I certainly believe the building official and don't want to appear as if I don't know statute, but they were under the impression that this had a CO because that's what their design professional had told them. Obviously, I need to help them sort that out and figure out, you know, what is actually submitted and what is properly submitted. So that's my job, but they were under the belief that this was settled. And the reason I was engaged so late is because they thought that this was going to be in compliance at the time of the hearing.
Well, I have a hard time believing that since your client is a electrical contractor. But nonetheless, not what you're telling me. I have a hard time believing that he didn't know that. I do definitely believe that that's what you're being told. And I would just caution, as I know you know very well, the homestead application, it has a penalty of perjury on the bottom of it, and you, when you fill out the homestead application, that is a very serious factual document that you submit to the county. So I just want to put that on the record as well. So we will go ahead, we'll give you till July 10th. It seems to me now that this private inspection is not available. If it is for some reason because there's some misinformation that the county has and they can go through that process, I would just suggest that they work with the county to make sure, whether it's the county inspecting or a private provider inspecting, that everything gets provided and finalized by July 10th, and that the county is allowed on the property to verify compliance, so that we do not find ourselves back here with a very hefty fine.
Understood. And I think in any case, that will be enough time to sort through everything.
Okay, great.
Thank you.
Excuse me, Madam Magistrate, just for clarification. So if they do receive their permits by the July hearing, they'll be able to keep everything they have on their property. If they do not, then everything needs to be removed. Because the building department case and my case, we're separate entities, county, sheriff's office. So this was a separate violation from the building department. And I was able to be, because you had stated in your order, the papers be removed, they're still there. The only thing that I was able to say from the public right away was that their pool was taken down. It's just laying on the ground now. There's still a RV, there's still a trailer, there is an antique car. All those items still remain.
Okay, so there was a violation of my order.
Yes, ma'am.
Because those things had to be removed.
Yes, ma'am.
And if I can interject, we could potentially propose, and this might be another sidebar I would have to subject you to, but an earlier date by which certain items, could be removed, because in recognition of the fact that, it may take some time to kind of navigate the permitting process. And if we're not able to do that within the next, 30 or 60 days, perhaps we would have to remove certain items while it's pending and prior to those items becoming permitted accessory or ancillary storage.
So the unfortunate part of that is that was something that I made very clear in my last order, that the things that were not affixed needed to be removed. And I spelled that out. The accessory structures which are not affixed to the property, including but not limited to the RV, the boat, the pavers, the above-ground pool, and other materials that were not affixed, because no one had been able to get on the property to verify what exactly was not affixed, that they would be removed by the 7th.
And I did ask my client before we met, and I'm trying to find the list that she gave me. I found it. What was removed, I really asked them for all of their homework in between the last hearing and this hearing, and they provided me with a list. So the list is a boat on a trailer, equipment including a lift, an equipment trailer, cars were removed. They are still waiting on the owner of the RV to come and pick up and remove the RV. And anything else that's being sort of utilized is being utilized for the purpose of the kind of ongoing permitting issues or construction issues. But if we want, there are certain items that are there that are, need to be removed. I would certainly entertain a very short sort of removal window that would not kick those out to July.
Okay, so actually the testimony from Mr. Lima at the last hearing was that he was going to put the boat on his vehicle and tow it out of there that day, the day of the hearing.
My understanding is that it's actually locked, and it's, I can let him testify to it if you would like to hear from him, but it's owned by someone else, and they sort of have a license to keep it there. It was taken off the property prior to today, but he tried to take it off and was advised that that would be illegal.
Well, his whatever license he may have is illegal, because he's not allowed to store equipment on a piece of property that doesn't have a permitted dwelling on it.
This is true, yeah.
So his license isn't very valid.
But I just want to underscore that I do appreciate, the interest in having whatever that is not affixed removed while, we're going through the permitting process, especially given that you've been understanding with the amount of time you've given us.
Officer Hill, are you working all of next week?
Yes, ma'am.
Okay. Okay. I'm going to, the specific items that I said needed to be removed, the items which are not affixed to the property. Again, I'm going to list what I know of, but anything that's not affixed to the property needs to be removed, and without having the ability to inspect, this has caused the problem. So I will give them until February 13th. They need to have someone available to meet Officer Hill on the property on February 13th. I'm not going to give you a time. I'll have her coordinate that time with your client to verify that the RV, the boat, the pavers, the above-ground pool, and any other material that's not affixed. And I understand that they may have construction materials, but the problem is they don't have a permit, so they can't have construction materials on the property without a permit.
Well, my understanding is there is an active permit, and I
thought it was expired because for inactivity.
I know that it was renewed in September of last year. My understanding that it was currently active.
Okay, let me verify that from the building official.
Yeah, as I stated earlier, we did renew the permit.
Okay.
That is for the barn itself.
Okay.
The interior work needs to get through the revision process, and that is where we're at with it. It's still on their side to respond back to plan review comments, and so nothing's been approved for any kind of living abilities inside this barn at this point.
Okay, but there is a permit. So
Permit
construction.
for the barn, correct.
Okay. So construction is going on the property for the barn.
Well, the barn looks like it's completed, and it looks like there's also been 2 additions to the barn, which are not on the plans as well, from what we can tell by aerials.
Okay.
So that will also need to be revised as well.
Okay. Did you hear that? That there are revisions to the barn that aren't on the plans for the permit that has been issued. So the permit is going to have to be revised in order to bring that up to date also, but that is in that other case.
Sure.
So then I will give till, I'll give till 5 p.m. on the 13th so that they can make arrangements to meet with Officer Hill on the property on that date to show her that the RV, the boat, the pavers, the above-ground pool, and any other affixed material that's not being utilized for a valid permit purpose, I'll ask that Ms. Hathaway attend with Officer Hill to verify that we're only doing construction on this barn, understanding that there are additions that have been made to the barn and there are permits that are going to have to be revised, but that only construction work is being done on a building that has a permit. If all of those items are not removed by the 13th, then the $150 day fine will revert back to February 8th, and will begin accruing. Obviously, there will have to be a compliance hearing for me to verify that, but I will retroactively send the fine back to February 8th if compliance with those items that are not affixed to the property is not verified by February 13th at 5 p.m. And then the remaining items that are accessory structures, they'll have to obtain permits for those accessory structures just because those accessory structures are on the property now, and they would be permitted if there was a primary structure there. They're still going to have to receive permits, and they, to the extent a permit is needed. So all of that will have to be done as well on all of those accessory structures, and I will extend that compliance date till July 10th. If that is not complied with, then that fine of $150 a day will revert back to February 8th today.
Understood.
Okay.
Madam Magistrate, if I may ask a couple questions, just for clarification. The July 10th deadline, is that for the storage containers that they would need a permit for? Is that the only accessory structures that you're looking at for that?
What other accessory structures do we know of that are on the
That would be the
property?
only one
Those are-
that would,
Okay,
Correct.
so they would need to permit any accessory structures that are on the property. That would be all that's remaining
Okay.
for the July.
in reference to the pavers, are you referring to the pavers that they needed to remove, are they the ones that are already laid, or the piles that it's kind of hard to see through their gate since I didn't have access, that is in the photo on the right, or both?
So the ones that are already laid are affixed to me and can have a permit that is obtained for them ultimately.
Okay.
So I am fine with those remaining, provided the permit is received for those by July 10th.
There's no permit required for pavers.
Yeah, there's some disagreement with my client that they don't believe that permits are required for pavers, but I believe, we'll sort that out. So, and if no permit is required for some reason, obviously that condition will be mooted, but just wanted to note for the record.
Let's get some testimony as to whether they're,
Afternoon, Megan Sonorski for the record. The respondents have been advised previously that part of their building permit application for the revision for the single-family residence, they are required to obtain a site plan from planning and zoning because there's fill violations that are on the property that may have encroached into wetlands. So they do need to have a site plan as part of their building permit application submitted. Those pavers would be part of that site plan application.
So the requirement to have a permit for the pavers is sort of
a site plan approval.
subsidiary.
Because there's drainage issues related to the fill that have been brought in, the pavers will be part of that site plan.
Can we just craft your order, Your Honor, just to say that provided that any are required,
Yes.
such permits will be obtained?
Absolutely.
Just to provide coverage? Okay,
Absolutely.
Thank you.
Do we have to show where the fill issues are?
Well, we were not going to be able to sort. I'm sorry for the record, they're just asking about where the fill issues are, but I don't think that's the subject of today's hearing, so
Yeah, that's
we'll
not.
sort that out.
Absolutely. Yes, sir.
Jim Potter, Seminole County Development Review, professional engineer and part of the development portion of this.
And did I swear you in earlier?
I was
Okay,
going to ask for
perfect.
you to swear me
Okay. Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Again, as part of the building permit itself, and I know this is more of this not having a structure, but as part of the building permit itself, there's required to have a site plan that shows limits of the clearing, the limits of impacts based on the building, based on multiple aerials. That limits has been substantially expanded. We have evidence that more than the required fill for strictly a metal building was placed on the property, and have, as part of that, as Megan said, required a site plan for this to allow the additional things that have been done. And to date, we have not had any contact about the site plan portion to deal with that. A site plan would be required. The pavers could be permitted as part of that, but again,
Okay.
as such, again, the additional encroachments that we believe have been to impact wetlands, removed additional trees outside of a normal structures safety zone. So again, all of that relates to the site plan that we are requesting be submitted to alleviate any and all of those violations.
Okay, and I believe that Mr. Love has indicated that he's going to work with them and walk them through that process, and that would be the July 10th deadline date. That would not be prior to, those are
Yes,
things
absolutely.
that need to be done by July 10th.
my client just wanted me to mention that those were apparently violations that were previously issued and were closed out. I do not know, and I can't provide any more additional information. Again, I'm intending to help them navigate this process.
Okay.
So much of this is sort of background information for me to, moving forward, which I do appreciate people providing.
Well, and I think as long as you remain in contact with the county officials, I think that is going to be what helps them get through the process. So I appreciate your willingness to do that. Okay?
Thank you, Your Honor.
Thank you.
Yes, the last one came.
Okay, let's call the last case, 2334 CESM, Kevin King.
Yes, ma'am. For the record, name is Vicki Hathaway, Building Inspector for Seminole County Building. In regards to case number 2334 CESM, Kevin P. King at 3200 West Osceola Road, Geneva. Notice of the hearing certified mail. Similar notice of violation was also Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the Special Magistrate on March 9th of 2023. An order was issued giving the respondent a compliance date of May 8th of 2023. On May 11th of 2023, an order was issued extending the compliance date to November 9th of 2023. An affidavit of noncompliance was filed by the inspector after reinspection on November 17th of 2023. An affidavit of compliance was filed by the inspector after reinspection on January 10th of 2024. The estimated administrative cost to process this case to date are $703.06 for both the inspector and the clerk. Recommendation that the special magistrate issue an order reducing the fine to administrative costs totaling $703.06 and order these costs to be paid within 30 days or the fine will constitute a lien on the property. This concludes my presentation.
Okay. I'm going to go ahead and order that I'll amend my prior order and reduce the fine, pardon me, I'm going to find that the property is in fact in compliance at this time, and I'm going to amend my prior order to impose a fine in the amount of $703.06, which represents the administrative costs of the county in this matter, in order that it be paid in 30 days and will constitute a lien against the property. Thank you.
Thank you. We know how well that worked.
Okay, I think that's all of the cases for today. I'm going to go ahead and set the next magistrate hearing for March 14th at 1:30 p.m. Thank you.
Thank you.